Welcome to our weekly immigration news podcast. We do a once a week podcast covering all things immigration in the United States. Today we've got a handful of stories, not too much. We're going to hit number one, the L1B. The L1B is a specialty visa, and there's some news out right now about denial rates. Cover that story for you at the top. Next, we're going to talk a little bit about the EB5 program. The EB5 is the $1 million or $500,000 investment program. There's been some developments in that program. Got some updates for you on that. In addition, we've got USCIS has somehow said that they want to increase the amount of people filing for EB cases in the Category 2 and Category 1. We've got some questions from you guys and our H1B quick tip. We'll put the time links down below if you want to jump ahead, check the story out. But as always, we'd love it if you give us a thumbs up, a comment, or a share. Helps us get our information out there because we do tons of immigration stuff. All right, let's kick it off. Recently, USCIS has published some numbers, and we get these sort of quarterly, but the numbers right now were specifically regarding the L1B program. Now, what came out is the L1B program has a denial rate that is somewhere in the range of 24%. Now, that is extremely high when it comes to employment-based cases. In fact, most H1B, the denial rate for H1Bs is somewhere below 5%. And H1B renewals is somewhere in the 2% range. So to get a case denied in the world of H1Bs, you've got to have an out-of-the-box situation where you're not filing the case properly. Let's be honest. 4% denial rate, 2% or less denial rate on renewals. It really is, if you have the qualifications, you present a solid case, your chance of being approved is pretty high, okay? Now, the L1B instead has a rate of denial somewhere at like 24%. And the part that I think that is most concerning about this is that when it comes to employment-based visas, employers put a lot of effort in, a lot of time and effort into choosing their case, preparing their case, making a decision to do it, and then filing it. Keep in mind, you're talking about employers, companies that examine what they're doing, rely on professionals like us at our offices to advise them on that, and then they step in, put the budget behind it, and they'll file a case. It's not just the money. It actually hurts them quite a bit if a case is denied because they relied upon that staffing happening in the United States. Now, the L1B is an individual with specialized information. Typically, I explain that to people like, it's sort of trade secret. Are you doing something or have a process or a procedure that you have internally within your company that only specific people know? And then we need to bring those people to the United States. I mean, I make it pretty hard for the L1Bs. In the world of technology or tech companies, there tend to be a lot of that. There tend to be processes that are private or specific types of business solutions that are created that might not be copyrighted or patented because they're not exactly a new breakthrough in technology, but nonetheless, they are private and they're a very specific system that will help get something done. All right. So the L1B itself is a very, very good visa. The other reason it's a good visa, besides it being for specialized systems, is that typically you have to have somebody in your team who's overseas doing this job and you're bringing them to the United States, okay? So overall, the L1B has been very successful when I've had overseas tech teams who want to come to the United States to either develop a process, teach or train a process, or engage with a client on a specific kind of process that's internal to that company. The denial rate of 24%, extremely high. And what we're seeing and the conclusion is that essentially USCIS is setting a very, very high bar for the L1B, and they're not really being clear. They're not giving us a very clear idea of what suits an L1B and what doesn't. And that kind of clarity is good for functioning, it's good for understanding immigration in the system, and it's good for business, where they know they can pick somebody, they can put them into one spot, and they can get a visa approved. What I think needs to happen is USCIS needs to look at their policy memorandum, they're going to need to look at training, and they need to come out with a much more clear idea of what the L1B is, how it works, and how you get a case approved. I have some clients right now looking at those. We have some in the pipeline ahead of these, and we are really trying to find our way to make these cases that are approvable at a high rate, because we like to have a win rate at about 95%. 5% I can forgive, but 24% denial rate, oof, no good. We'll come back to you with more on the L1B as we learn more. Hopefully we can see the administration make some changes in this realm. Like I said, we'll put it back out there. Another problem that we've seen with USCIS recently is in the EB5 program. The EB5 program is a green card based upon investment. The investment program says if you invest $1 million and create 10 jobs, you will then get a green card. That has changed and fluctuated over time, and in fact there's actually a secondary type of case. That case is a $500,000 investment, and it's the same thing. Invest $500,000 into a company that creates 10 jobs, and you can get a green card. What's happened is, for about 8 months, it's been in limbo whether the $500,000 regional center, that's a type of private approved investment that qualifies for the green card, the $500,000 program has been in limbo. There's no clarity on what's happening. Nobody knows if you filed your case and it's still pending, if it's okay. Nobody knows if the program's going to come back online. There are people who are queued up to join these regional centers, to put money and invest, and nobody knows what's happening. The EB5 program has traditionally been approved every year around December, where they reauthorize the program usually for a short period of time, 1 to 2 years. And this has caused a lot of uncertainty. The fact of the matter is, the EB5 investment program was breaking ground 20 years ago when it first came out in the 90s, but now it's fallen behind. There's a lot of countries that offer different kinds of investments and different kind of incentives for capital investments that allow people to get residence. In fact, Canada has a wide array of different programs. Some of those, depending on what province you're in Canada, will allow somebody to invest in a small business, purchase a home, and get residence. I've had clients do it. So at this point, this program, the EB5 program, is suffering. The lack of clarity makes it very difficult for individuals, foreign investors, to come and put their money here. And more importantly, the United States is falling behind. Being a country that accepts capital investment to spur the economy and gain an immigration benefit is a great idea. The fact the United States isn't doing it and we're falling behind, and Portugal's ahead of us, Grenada's ahead of us. There are countries in the Caribbean that will offer a green card real fast on a very small investment. And what we're seeing right now is we're seeing this program flounder and fail. We're looking for the Biden administration to make some progress on it, to say something about it, and perhaps reauthorize this program in a way that makes it live a little bit longer, have some stability, and can go off into the future. I'm not sure how this administration is going to get there, because you need Congress behind that. You need to maybe reauthorize this bill, but we need to see that happen. We'll be back with you more information on the EB5 as soon as we know more. Right now, if you're looking at investing, be careful, because the $500,000 Regional Center program is in limbo and it's not open at this time. Recently, USCIS put out a tweet and on their page announced some information stating that people should be looking to move their EB filing into the EB2 category, the EB1 category, out of the EB3 category. All right, very confusing. It seems to be that USCIS is saying you should be moving to a new category because of the availability of specific numbers within that category. It's really not absolutely certain that that's how it works, because the truth is within USCIS, I believe that categories fall down into each other. EB2s fall into EB3 as they have cases in a year. So the USCIS announcement where they're encouraging people to move, I think that would only be applicable if you're from a country with a long backlog, where the EB3 backlog is several years longer than the EB2 backlog, and the same for the EB1 backlog. And that would really only apply to China and India. This announcement by USCIS is going to be a little bit confusing, and I would suggest you talk to an attorney about it before you do anything. Moving categories is not impossible. It's very doable, and I think we all went through it about a year ago as we were trying to get ready for the big year in 2021 for employment-based cases. But you should talk to your attorney about this. I don't suggest that you just jump categories or file a request to change categories. I think you should actually talk to your attorney, make a plan, and see what makes sense. Just because USCIS said it doesn't mean it's the best way to go. All right, we got our H1B quick tip. H1B quick tip is very simple. It's called CAP-GAP. If you don't know about that, you need to know. CAP-GAP is a policy by immigration. It's not a law, it's a policy. It must have gone into effect at least 15 years ago. I can't recall exactly when. What CAP-GAP says is that if you have OPT, and that includes STEM OPT, and your OPT ends after April of any individual year. And that same year you file for H-1B and get selected for the lottery, you will get an automatic extension of OPT from the time your OPT ends until October 1, okay? Automatic extension of OPT until October 1. This means that if you're selected for the lottery, and so for example, I had a call this week. Her OPT ends in July this year, this summer, and she asked me what she's gonna do. She's gonna file for the lottery. By filing for the lottery, if she's selected, she gets an automatic extension of her OPT from July to October. And it's so simple. All you do is take your selection notice down to your DSO at your International Student Office, show them you've been selected, they'll issue you a new I-20. There's no work permit, it's just an I-20 because it extends you 3, 4, 5 months and gets you up till October 1. Keep in mind, cap gap only works for people who end OPT after April 1. If you have your OPT end earlier, but your 60 days, because F1s are F1 plus 60, extends, you do get cap gap, but you don't get it with the work authorization. All right? If you got questions, call your attorney. They should know about this. Okay, got a couple questions from you guys. Let's hit them up really quick. First question is, which is faster, the marriage or fiancé visa? All right, which is faster, marriage or fiancé? These are very complicated questions because it depends on whether you're in the United States, visiting on a tourist visa, or you're overseas, or what. Right now, because of COVID, we have long lines at the consulates overseas. And we all know that the Biden administration put out a priority list last year. And in that priority list for people who get interviews at consulates, it is family members of citizens. That means spouse or children of citizens, actually the #1 group, which translates into a higher likelihood of getting an interview if you're married to a United States citizen. Now, this is a very general advice, and it does not apply to every single case. The fact of the matter is every consulate's different. We're seeing long lines someplace, short lines elsewhere, and we're seeing people get in for interviews on an F1 and in some places not getting in at all. So it's gonna be very, very fact specific. But right now I would tell you that a marriage case under the current guidance puts you at the top of the list, whereas a fiancé case, the K1, is not really on the list. And in fact, there was a lawsuit last summer of 2021, where a group of 300 to 500 K1s sued the government saying, we're not getting our interviews. That case settled, and those 300 or 500, whatever it was, group of people were allowed to get into line and jump forward and get an interview, okay? But it did not apply to all K1s. So it's very complicated out there, and if you don't know what's best for you, talk to a lawyer, get some good advice, and make a good case plan. Our last question for today is, can I attend an H-1B while I'm residing outside the United States? Short answer here, absolutely. H-1Bs are for individuals who have a U.S. employer, okay, who's hiring you for a position that is a college degree position or higher, right? University educated position or higher. If you live outside the United States and the employer wants to do a case for you, it can absolutely be done. And in fact, we've done it. We had one approved pretty recently for someone that we filed last year, and it was Guatemalan working for a company here, and was already working for them, and we did the H-1B, got him approved, and he's moved to Texas where he's working for them right now. All right, guys, that's it for today in our weekly immigration podcast. Thank you for watching all the way to the end. We always appreciate all our viewers. Like, subscribe, leave us a comment. We actually respond to your questions in case you didn't notice, and we appreciate everything you guys do. So if you want to give us a comment, we'll definitely check it out. Stay safe. Thanks. Bye.